Welcome, everyone. Thanks for joining us for our webinar here today on minimising legal risk in NDIS staff hiring. My name is James True. I'm a practice group leader here in LegalVision's employment and safety team. My co-host here is Bianca Shapiro. Now, Bianca's a partner and COO at MyCareSpace. Bianca, would you just take a moment to tell us a little bit about MyCareSpace before we get started here?
Yeah, sure, James. Thanks. Look, it's really obvious why you're here, because you're a lawyer that really has this particular expertise in employment contracts, which is what we all need as NDIS providers. MyCareSpace is a platform that connects NDIS providers with customers. We essentially sit between people that have NDIS funding and are looking for services and providers of those services. So I am talking to hundreds of NDIS providers a month, from the single guy that's just started a business on his own to large organizations that have moved into the NDIS, or perhaps even organizations that have been really successful in the NDIS to date. So I have a really good feel for where providers are successful and where they aren't, and the challenges that they have. So I think we're going to be really helpful today.
Yeah, great. Hopefully with each of us, you can kind of be providing that sort of on the ground experience, and I can handle the legal overview. So the idea is it should be, very particularly tailored for the NDIS today. So before we get started, just a couple of quick housekeeping items. You'll receive the recording and the slides in your email afterwards. Throughout, please feel free to submit questions in the chat box. We will try and answer what we can at the end. And then otherwise, we'd really ask that you complete the feedback survey at the end of the webinar. The feedback is really important for us. We just want these webinars to be helpful and useful for you, so we really do take on board your feedback. Also, you're going to be eligible for a free consultation with LegalVision, basically for us to sort of have a conversation with you, identify if there are any areas where LegalVision can help. It's a sort of a legal health check, so we might be able to identify some issues that the business might have in sort of all areas, not just confined to what we're talking about today. So leave your contact details in the survey at the end of the webinar. And you may also want to use that opportunity if you've got a question which we are not able to get to. You can use that consultation. That's something we can try and help you with in a consultation afterwards. So in terms of what we'll be discussing today, first up, employees versus contractors, and what's the distinction? Contractors in the NDIS, employees in the NDIS, what type of contracts you want to use when you're recruiting, understanding the SCHADS Award. We'll cover that at a fairly high level because it's a pretty complicated beast, but we'll then have some time for Q&A. So again, submit your questions throughout. All right, well, to kick us off, I'm going to start and I'll be speaking about employees and contractors. Now, the question here is really what determines whether your staff are employees or contractors. And this is a very hot topic. Legislation, which is literally just passed about a week ago, has made some very significant changes in this area. So before last week, the way you would determine whether or not someone was a contractor or an employee was really about looking at the contract that you have in place between the parties. And that effectively meant that if you had a contract which looked like it was setting out an employment arrangement, you had employment. If you had a contract which looked like it was setting out independent contracting arrangements, well, then that's what you had. That made things pretty simple and reduced a lot of risk for businesses when they were engaging contractors. Now, that's not the case anymore. Under the new laws, the meaning of employee and employer will be determined by having a look at the real substance, like the practical reality of the relationships between the parties. So that really means looking through the agreements you've got and actually making an assessment of how the parties behave. If we go back to basic principles, if we're going to determine whether something's an employment relationship, well, employment's one really where the worker is in the service of the employer. So they'll be engaged for certain hours, and then they perform work that they're asked to do during those hours. That's the basic tenet of employment. Contractors and contracting arrangements are relationships for services. So effectively, that's where you've got a contractor. They will typically carry on their own business, and then they provide services to the principal. So they're mostly paid to achieve a result rather than, say, by reference to an hourly rate. If a court tribunal is making an assessment of this relationship to figure out what it is in substance, they will consider it by various indicia, which are largely under the headings of integration and control. So if we're looking at, say, control, the question is, well, how much does the principal or the employer, whatever it may be, how much control does it exert over the manner in which the work is performed? If there's a high degree of control, it's more likely an employment relationship, lower degree, more likely contracting. They look at things like financial responsibility and risk. Contractors typically bear all their own financial responsibility and risk because they're running their own business, whereas if that's not the case in employment, the employer is liable for all the acts and practices or omissions of an employee. They'll consider who supplies the tools, the equipment. So contractors typically carry their own tools of trade because, again, they run their own business, and employees have all of those things provided by the employer. Whether or not there's a right to delegate or subcontract the work is also considered as well. Of course, employees can't subcontract or delegate their work out to a sort of external third party, whereas that is typically okay. There can be limits on that, of course, with independent contractors. Hours of work I mentioned before. Employees are typically, because they're employed for service, they get some set hours, and during that time they do the work that they're required to do. Contractors have a far greater degree of control about when they do and don't perform the work. And then finally, there's an expectation of work continuing. So contractors, typically, if they're engaged for a task, well, the engagement would end when the task is complete. Now, with most employment relationships, you're employed in an ongoing, indefinite period of time until that relationship is terminated. So there are obviously a lot of factors which get considered, and not any one of those factors is determinative in its entirety of what the relationship is or isn't. All of those factors get considered. But the key takeaway there is, if you're engaging someone who's carrying on their own business, coming to provide services to you, you can be confident that that is appropriate to call that a contracting arrangement. Equally, if you've got someone who's under your control and in your service, then that's more likely to be employment. We'll talk a bit later about what do you do then if it's employment or if it's a contracting arrangement, but it's important to get that right at the start. So I'll hand over to Bianca.
Okay. Yes, James, I've been waiting for you to finish that because that was very formal, and that's that the sort of legalese around it, and that would be fine if we were hiring someone to develop a website or do a cleaning contract. But in the NDIS, we see a very common relationship which occurs with providers, which is where they are hiring support workers to deliver support for them as a care company, or perhaps they are a therapy company and they are hiring occupational therapists and speech therapists to deliver those services on their behalf. Now, one might call them contractors. I am hiring support workers, I'm contracting them, I'm getting them to fill my support clients' needs, and the same thing for therapy. And as I was listening to you talk, the one thing that really struck me with there was the control over that work. And, sort of often our understanding around this is, oh, we're going to hire contractors to deliver care work and contractors to deliver therapy. But are they actually contractors? Because if I have hired 5 people, I'm controlling them. I say to them, okay, I've got a participant. You're going to go there for 5 hours on Wednesday. You're going to go there for 5 hours on Friday. Would they be an employee or a contractor in reality to me? Because I'm telling them what to do. I'm telling them how many hours to work. I'm paying them for that work in this NDIS space where that is a very common relationship. Is there a way to determine that?
Yeah, I'd love for there to be some super black and white test, and unfortunately, like many
Yes.
things within the law, I'm going to use the word grey area. Having
Mm,
said that, I mean, you obviously, yes, you raise a really good point. when you look at that question of control, it's not necessarily always just control in terms of, okay, I've told you to go to a certain site and I've told you how many hours I want you to be there. Control goes a bit further than that into the question of, well, are we controlling the manner in which they perform the work? So literally in terms of how they may execute those duties, not just the where and when. So that's the next step consideration there.
Wow. And that is grey because you'd only have a certain amount of control over how they delivered that care or how they delivered that
That's
therapy.
right.
And that's the whole reason we're here. That is the whole reason why we are delivering this webinar with LegalVision. I might add that MyCareSpace is a client of LegalVision. We have been using LegalVision to support us in all of our legal decisions. And the very first thing that we hired LegalVision for was for employee contracts. So this is a topic that, I have been in from the start, and it's very difficult to determine and make these decisions as a layperson, as a business person, because the law can be so gray, and that interpretation, and what you're going to share with us later when we get into those different types of contracts, if they are a contractor and if they are an employee, is what happens if we've made a mistake and they're not actually. So that's the kind of thing, and you must see that all the time, James, when people come to you going, oh, we've got these contractors, and you look at it and you go, no, I don't think they're contractors. You need proper employee contracts. Am I
100%.
right?
That's right. And so that's why when you're getting started, to make sure you're not moving on with, liability that you're not aware of, get it right from the start. And although it's great, we can help you find an answer to it. And that's why, as I mentioned, that not any one of those factors are entirely determinative. So
Mm.
there can be a relatively complicated process to work through it. And then, of course, if the answer is still it is falling in a grey area, you need to then understand, okay, well, what is the risk for getting it wrong? And we'll talk about that a little
That's
bit
it.
later.
The risk. So look, let's assume we know they're a contractor, and we have an NDIS business. What would the benefit of using this more casual relationship? And I say casual because there is a very big difference between a contractor and employee in a business. We have had contractors at MyCareSpace. We have a lot of employees at MyCareSpace. And having spoken to providers in the marketplace, particularly with this webinar coming up, I was asking them, so what's the benefit? What's the disadvantage? Would you use contractors? Would you only have employees? So the advantages of having those contractors is sometimes, as a small business, you can't guarantee the number of hours that you need that person for. And that's really tricky. If you're employing someone, part of that employment contract is how many hours a week you're employing them for. And those people want and expect stability and a set wage that they get every month or every 2 weeks. So having a contractor does give you that flexibility as a brand new provider to just try and start that building, get your first participant, your second participant, without having that commitment of employees. I mentioned earlier support workers. We see a lot of contractors. We see a lot of contractors in allied health. And support coordination as well. There's a lot of independent support coordinators in the NDIS that have contractual arrangements with the companies that they're working for. Hours and pay, again, especially in these types of services, the hours are not fixed. Support work is not from 9 to 5. It might be an overnight stint, could be in the middle of the day, it could be just personal care in the morning. And same with support coordination, they have varied hours through the month or through the year that they're delivering. So a contractual arrangement as a business, that might be more helpful for you. Training and skills, that's really tricky. If you are engaging a contract to deliver your services, there is a contractor, there is an assumption that that person has the skills necessary to deliver that service for you. If I am contracting an OT to be part of my group and they're delivering OT or speech, there is an assumption that they have that training and skills to deliver that service. Now, obviously, they would demonstrate that training and skills in some way, but you wouldn't necessarily be expected to train them as a contractor to deliver services in your business. And finally, one of the things that James already mentioned, financial risk. No work, no pay. You know, if a contractor doesn't work on that particular day, you're not paying them. If your employee is sick, you're paying them. If they're taking a mental health day or personal carers day, you're still paying them. So the contractor arrangement does help limit the financial risk that you hold over that. On the sort of downside, a contractor still might not necessarily be part of your family. They may be more expensive because they're not getting all those employee benefits. They're not getting paid leave and paid sick leave and personal carer leave. So their rate, in essence, should be higher because that's all they're getting from you, their salary. They can be unreliable, and it's not all contractors, by no means, but the nature of a contractor is that they're not in your family. They're not with you all the time. They don't perhaps, and again, this is a generalization, they don't perhaps have that same connection with the company culture and values. So they might not always be acting in your best interests. When you do start growing rapidly, that contractor might be working for other people. It's likely that they're working for other people, that they're not only working for you, because I believe that also might influence whether they're an employee or a contractor. So, suddenly you need that person for more hours and they don't have it. And then you'd have to go and try and hire more people to manage your own growth. And then the other points in the slide that I have already mentioned is that company culture and law and the things that you build within your team, which that contractor might not be part of. You're not going to pay the contractor to come to your Monday morning meeting. You're not going to pay the contractor to come to your Friday drinks. All of those team building elements that bring your staff together, you're not necessarily going to be willing to pay that contractor to do those things that aren't actually delivering services. So they might miss out on being part of your organization. Now, if we moved on to the next slide and look at employees in the NDIS, that's kind of a bit flipped there. Employees have benefits. They are more loyal. They do value the fact that when their child is sick, they can take care leave. As an employee, that's an employer, it's not always great, but as an employee, that is a benefit that they have where they are employed full time. We have that workforce. I might have an employee that I have scheduled or rostered in their contract for a set amount of time a day, and I might not actually have all those hours, but when I do, then I have them on the spot ready to deliver that service the next day or the day after. I don't have to go scrambling around trying to organize hours with somebody. Company culture can be built, yes, absolutely. And that does happen when people are close to you. And then also employee training. We expect to train our employees. We expect to build their skills. The NDIS actually does expect you to do that with whoever your staff are, whether they are contractors or whether they are employees. But you're most likely to do that within your team. And again, when you do have that growth, when you do that promotion, and man, from one day to the next, you're taking on participants, you're delivering more therapy or more support, you've got that staff base ready to add those extra hours to. Now, again, having employees, you're paying them for that set amount of hours, and if you don't have those hours that week, it doesn't matter. You're still paying them for that time. So that is a financial risk for you. Also, the benefits, leave, and sick leave, and personal care leave, and mental health leave, and domestic violence leave. All of those are amazing benefits to employees, but they do take a toll on an employer when they have to pay those benefits, but you don't actually have that staff person working for you. And again, as much as you love your team and you love your employees and their families and their kids and their partners, every problem they have is your problem. When their kid is sick and they need to work from home, they work from home because they're part of your team, and you have to do that. Whereas you're less likely, if a contractor comes and says, look, I can't work this morning. Well, they are less likely to even do that because if they don't work, they don't get paid. So yeah, with your employees, their highs are your highs and their lows are your lows as well.
Yeah, I mean, thanks for that, Bianca. I think that's really good in terms of just covering what it actually in practice means. We can talk about all the kind of the legal distinctions
Mm,
between them, but really good to hear about it all in practice. And probably the thing that I'd add to that as well, when it comes to employees, those benefits are absolutely all there. But it's the ease of exiting the relationship too. So when things are going wrong, as you say, with a contractor, typically pretty simple to terminate that arrangement. Sometimes that's the case with employees, but some employees will be protected from things like unfair dismissal. And so there are a few hoops you've got to jump through as an employer. So definitely more agile having a contractor, but you are definitely missing out on all those many benefits that you've mentioned. So I'll go into coming back to this sort of an extension about what I was talking about before, but this is really in relation to, well, what would look different in the contract with an
mm.
independent contractor.
So, James,
This,
can I interrupt you for a moment and ask you, as an organization, would I come to LegalVision? When we came to LegalVision, we only had employees, we didn't have any contractors. Would we come to you first and go, this is the scenario, this is what this individual is delivering for us, what do we need? And then you would tell us, okay, you'd ask relevant questions around the industry and the service delivery, and then you create those contracts. But would you help us decide or decipher whether they are in fact contractors or employees first?
yeah, absolutely. I mean, ultimately, where we would land would be, it's your business, you can decide on it. But the thing that will help you with is let you know what the risk is if you go down one way or the other. So definitely, we would say, look, having regard to the arrangement, what you're describing this is going to be, if this was ever challenged, we think that a court would definitely say this person's an employee. And therefore, if you call them a contractor now, just know that moving forward, you're going to be carrying some liability for potential back payment claims and things like that. We'll talk about those other what happens if I get it wrong arrangements.
Mm,
So, but it would still ultimately, the business may say, look, I understand that, but I need to carry that risk because I need the flexibility of being able to just pay an invoice if they've performed the work. I'm not at a level where my
mm,
business can actually employ someone. And so, but our job there is to tell you, well, this is the risk that you're going to be carrying if you proceed on that basis. And then, of course, you're going to need to get the contracts correct. And so we'll draft all the contracts for all of our clients. So all the employment contracts, independent contractor agreements, absolutely. That's something which we would do. It's very
mm.
common piece of work for us. So
And
looking at,
what I found most interesting, yeah, on your slide there, and our own experience at MyCareSpace is, there's often a vague understanding of what a contractor is, but I didn't realize that there were so many different types of employees as well. So, yeah, I'd love to hear the difference between them.
definitely. So that's right. It's not just contractor or employee.
Mm,
When you look at employment, there are three main types really. You've got full-time employees, so they're ones who are working 38 hours a week, and they'll work to a fixed, typically a fixed number of hours per week, which is that 38 is the kind of call it the maximum load. So a full-time employee, and they're employed on an ongoing basis. They're permanent. They're there until you terminate the employment, and you might terminate for any number of reasons. Poor performance, they might resign, or you might end up having to make them redundant when you don't have any work for them. But they're typically the reasons the employment relationship ends. But if no one terminates it, it continues on. Another type of permanent employment is part-time employment, and that's any employee working less than the 38 hours a week. But they still, so even if someone only works a day or two a week, they're still, if they're a permanent employee, engaged on an ongoing basis with an ongoing expectation of work. So they're permanent, and again, you set their hours and you provide them with the work, and the employment continues until someone terminates it. Now, there is a more agile type of employment, which is casual employment. And casual employment is basically just where the employee is engaged on an hourly rate basis. They don't have a fixed roster. They don't have an ongoing expectation of work. So basically, you can say to them, I've got 12 hours of work for you this week. Here's the roster. The trick is that, well, I guess the additional factor is they're not obliged to accept that work. So they are entitled to say, no, I don't want to work this week. So they are probably the closest thing to a contractor whilst being an employee. But as I said, they're engaged on an hourly rate, and they don't get things like annual leave, sick leave, all of those permanent entitlements, but they're still employees.
Oh, you're going to
So if
hate
we
me
look,
now, James. I have to ask you, but why is that so close to a contractor? What's the difference? It sounds exactly like a contractor.
yeah, so
And
they're not running.
why would I have a contractor or a casual employee? Like,
Yeah, they're not running their own business. So it's really a lot of the
okay.
duties that they would owe to you. So as your casual employee, while they are performing work for you, you've got complete control over them in terms of how they perform their work
Mm,
and what they, the uniform they wear, what language they use in their emails when they send it to clients. You've got complete control over all of those things, and they have a duty to basically serve you faithfully, as every employee does. Where you have a contractor, yes, there are some similarities there, but the contractor is then also managing all of their own personal, say, tax requirements. They're running their own business and they're sending you invoices. So, obviously, with a casual employee, you might be then paying their super, and then you're remitting pay as you go tax to the ATO. And so, yes, there's a simplification with a contractor, but a lot of casuals, they don't have an ABN. They haven't established their own business. They're not set up to send you invoices at the end of every month. So there's a little bit of an extra barrier to entry, I suppose, of becoming a contractor. So some people might come to you and say, well, I'm actually not in a position to be a contractor, and I only want this
mm,
kind of ad hoc arrangement with you. Then casual employment would be the way
mm,
to go.
okay.
The other things that will come into that is that person may not, in terms of not being ready to be a contractor, they might not have things like insurances available so that when they are going to perform the work, that is actually insured under some kind of professional indemnity or something like that. So it's a very different, it's not a business to business relationship, and that's probably the distinction. I'll talk about those clauses in a contractor agreement there,
Mm,
and just some things you want to get right. Now, obviously, with a contractor agreement, you want this it's a complicated and needs to be a detailed legal document. So it goes a little bit beyond these four dot points that we've got here. But things to get right, a fee structure. You want to make it very clear what they get paid in return for providing which service. That's probably the most important function of that agreement. How are we actually paying and what do you have to do in order to get paid? And then moving on to the next one, when do we pay you? What are our payment terms? So once you send us an invoice, do we have 7, 14, 28 days in order to pay your invoices? So all of those things are typically negotiated. But you need to be very clear about that because that's probably one of the most common things businesses will have disputes over is actually about whether they're entitled to pay and then when they should get paid. The other thing is that because they are an external business to you as a contractor, they need to give you some promises about what they'll do about the information that you provide to them. Now, obviously, in the
mm,
NDIS, a lot of that information is going to be sensitive personal information, that being a specific term under the privacy legislation. But it also extends to your own company information as well. So, confidentiality provisions, assurances from them that they will comply with all privacy legislation is a really important thing to make sure your business is protected. You don't want a situation where that contractor makes a mistake, maybe in this instance, some kind of data breach, and your client ends up suing you, and you don't have any
mm,
recourse to pass that liability on to the contractor who's the one who actually made the mistake. So that's quite a critical thing in contractor agreements to make sure we're dealing with, well, who is actually liable. And again, that leads into the next one, which is the insurances. If you're just dealing with it might be a small, an individual makes a catastrophic mistake that causes your business millions of dollars in damages when you get sued, you're probably not going to recover that money by going after that individual. So it can be critical to see, well, what insurances are we going to require them to maintain? So public liability insurance, the accidents, incidents caused by them on the job, but also then critically professional indemnity. So if they make a mistake in the work that they're doing, we want to make sure that they've got sufficient cover so that if we do need to sue them, their insurer is going to pick up the bill and not leave it on our business.
And I think in the NDIS, particularly because it is an industry that is dealing with vulnerable people, where there has been a history of abuse and misuse, the NDIS and the NDIS Commission is very sensitive around things that NDIS providers do that they could have avoided. So, having that in your contract and you've taken those measures means that if something happens, you've demonstrated that you have taken that duty of care, and that is one of the NDIS requirements as a provider, is that you have to have duty of care to your participants and protecting their information, making sure that your staff or whoever's delivering your services are insured. Those are pieces that, as a NDIS business, whether you are registered or not, you're still liable to deliver and to have a duty of care to participants. So at least you can demonstrate that you've done that. And James, you've mentioned it a couple of times already, and that is the word risk. Most of the times what we're trying to do here is eliminate or reduce the risk. And, that's what these contracts are all about, right?
Yeah, absolutely. Yeah, practical risk in terms of actually trying to make sure they're thinking about the standards of that they're going to comply with, and then legal risk, making sure if it goes wrong, have we got a properly drafted contract to mean that if we run off to court and try and sue someone for breaching it, we don't get laughed out of court for either not having a contract or for having a very poorly drafted contract. So there are two things there that are really important to make sure a business is covering off, both practical risk and then the legal one.
And getting a contract template off the internet and then putting your own name on it is absolutely not an option in the NDIS. I can't stress that enough.
Yeah,
the risk there is enormous.
We do see that a bit, and look, there's ChatGPT and other kind of services on the internet, and to be fair to those things, sometimes they are correct. It's very hard to know if they are correct or not, but they're not always bad, and sometimes agreements you find on the internet can be appropriate. I think something we've discussed previously, Bianca, is you might look at an agreement and say that's fine, that's got what I need, but it's often what's not in the contract is
absolutely
missing. And the important thing about contracts is that if there's ever a dispute, remember that these contracts are the first thing that anyone is going to look at. It's sort of one of these documents that's not important until something goes wrong. So it can get signed, put in the
absolutely.
top drawer, completely forgotten about, and everyone moves on. And ideally, you never ever think about it again, and that's a good outcome. But as soon as something goes wrong, it's the first document that gets looked at, and it's the most important one. So it is sensible to make sure it's correct. The other thing is that the law changes, and so making sure that even if you might have got a completely appropriate contract 5 years ago, making sure that it's current, because you might find that the law has developed and some of those clauses in that contract are no longer valid, or what it says it's going to do for you, the law now says you're not allowed to do that in a contract. So there's a sort of a currency issue as well when it comes to contracts.
Absolutely. And I can add there that that's one of the benefits we have had from LegalVision service, is that because the nature of our subscription is that we can keep asking you questions about those contracts. I can say every 3 months, hey, James, anything changed? Do I need to update my contract? And you guys will tell me, and you'll redraft the contract, and that's part of my subscription. So I'm never worried about, oh my goodness, that's going to cost me another $400 to get that contract reviewed, or another few $100s. It's something that I can just keep doing and actually know that it's part of my subscription with LegalVision. And with that contractors, I guess the thing that I would say here, which we're often surprised at, is that it's often the really large companies that don't think necessarily about these contracts. And you're going to move on to employee contracts in a minute, but it's not only the little guys, it's often the big guys, because those contracts might be really quite old, and someone was doing them in-house. And it's actually the reputational damage if one of those contractors steals your participant data or does something when they are representing you, and you as a larger organization can't come out and say, we had contracts in place, we did everything right, we can't control that individual. That would be really brand damaging if you can't demonstrate that you've done everything that you could to protect yourselves and your participants, um, in that kind of scenario. Okay, but tell us about employees. How does that differ to contractors?
For sure. So, I mean, coming back to that sort of, um, specifically what we're talking about in employment, we're talking about a contract for service. So someone is there in your service, working the hours that you've agreed, and they're doing work for you during that time. Some key clauses. So in a similar fashion, you want to make sure that you've got a confidential information clause in there, protecting your company information and your client information as well. Critical things also, a notice period. So sometimes an employment contract doesn't have a notice period. When an employer, it comes time to terminate the employment for whatever reason it may be, if there's no notice period, which would say we can terminate by giving you 1, 2, 3, 4, could be 3 months notice, or a couple of weeks notice, whatever it may be. Without that, you're left to this concept of common law notice, which in some instances can be as much as 6 months. So we've seen businesses who had a contract not correctly drafted, didn't have a notice period, made someone redundant. So they had a redundancy payout of approximately 12 weeks for the redundancy. They had long service leave to pay out at around the 10-week mark. But then there was the notice period in the contract to deal with as well. And the courts found, well, for someone who'd been there, this employee had been there a long time, but said someone in, their personal circumstances, their length of service, you've got to give them 6 months. So,
Wow,
that company obviously saved
that
some
would be
money. Not
devastating for a business.
Yeah, that's right. And then really got stung by even just that, on top of all the additional entitlements, an extra 6 months salary for that particular employee, when if they just had a properly drafted contract, it would have been 4 weeks in that. So it can actually cost, very, very strictly speaking, cost you more to have a mistake like that. Clawback clauses are important to cover. The Fair Work Act is very tight on when you can deduct amounts from employees' wages, but a properly drafted contract will give you the best chance possible, really. And it's usually things, not so much if they make a mistake, you'll be able to deduct, damage or something like that from their wages. You very, very rarely be able to do that. But even things like overpayments you might have accidentally made to them, if they've sort of intentionally or negligently, lost some of your equipment, there might be times you can then deduct from that. So it's important to deal with that in a contract to give yourself the best chance of being able to recover where you need to. Privacy is very similar to confidential information. The confidential information side will cover all of your business's confidential information, your trade secrets, your know-how, your special sauce. Privacy is also going into setting those requirements about you're going to come into contact with our customers' information, and here are the requirements we're going to put on you. So it comes back to what you were saying earlier, Bianca. You want to be able to show that we've taken all the steps to make sure that these mistakes aren't happening, and this is ultimately beyond our control. The salary side of things, this is really critical, and it's a very common mistake. You need to understand whether you're actually going to pay someone one annual salary, and that covers them for all hours of work, or are you going to be paying them very strictly in accordance with the award, which we'll talk about soon. So are you going to pay them a base rate for some hours and then loadings, penalties for other hours that they work? So they're going to have a highly variable rate of pay depending on or when they do work for you. Or do they get a flat rate, which covers everything, which is obviously easier from an admin perspective? If they're a casual
Definitely.
employee, it's really important to specify exactly that they're a casual employee, but also that they're getting a casual loading. Now, the casual loading, basically casuals, because they don't get annual leave, they don't get sick leave, they don't get other permanent entitlements like notice of termination, but they do get an extra 25% on their base rate every hour. So they get a slightly higher rate every hour, but then the payoff for that is that they're very flexible, and they can be sort of terminated at any point. But it's very critical that the contract is it's clear about that, because if it's not, you're going to run the risk that that employee, notwithstanding that they've been paid that extra 25% throughout the life of the employment, they still might be able to turn around and put their hand out for back payment of permanent employment entitlements, like annual leave, sick leave, or a redundancy. They might be able to do that if you haven't been clear enough about that loading in the contract. So it's pretty critical. Stealing customers is another one. The NDIS is unique in relation to how restraint of trade provisions work, given the principles of choice that sort of pervade the entire NDIS. But if you are ever going to have the ability to prevent someone who's worked for you from moving somewhere else and then raiding your client base and bringing all your customers or clients with them, the only way you're going to be able to do that is if your contract had express prohibitions on it. There's no general right to do it for an employer. So for the clients who come to us and say someone's stolen our customers, they're literally reaching out to them every day and telling them to come follow them to their new job. First thing we do, take a look at the contract. And unfortunately, if those clauses are not in there, there's nothing we can do unless it's some kind of instance of there being confidential information being stolen at the same time. But it's very rare. If you want to stop poaching, you need an anti-poaching provision in your contract. So that's where it's kind of really critical.
And the problem with the NDIS, James, is that it's very competitive in many areas. And we do see that around therapy, large organizations that train up their team of allied health professionals and then those leave as individuals to work on their own and try and take their clients with them. And the same with support staff, support workers in companies who then persuade the individuals to pay them one-on-one and they leave that company because they're going to get a higher rate. So I think that is definitely a concern in the NDIS. And those clawback clauses, that's something that we learned about quite recently as an organization. When you have staff that are working sort of flexible times for you, like a few hours on a public holiday or on a weekend, I believe that those particular clauses are important if you're doing that with your staff, sort of different areas, because it could be very expensive if they work on a Saturday or they work on a public holiday, if you don't have any accommodation for those kinds of scenarios. Is that right?
Yeah, that's right. It all absolutely boils down to, again, in every single one of these instances, getting that contract right is critical. That is the place that records all of the agreement between you and the employee. So it's really important that it's very specific and very considered, and also that it's been put in place from the get-go.
And look, that's
Right.
the thing. The thing with employee contracts is it's not a natural piece of knowledge for us as business owners. No matter how large your business is, it's not something that you're kind of dealing with every day. Sales, marketing, bit of accounting. Those are things that you're probably being exposed to, but not things like this. Not making sure that you have employee contracts that have all those relevant clauses. I mean, many of those, even being in business for 20 years, I hadn't even thought of when I was in different business scenarios, and particularly in the NDIS. So I think the great thing about LegalVision is that they have NDIS specific knowledge. We find that a real problem for NDIS providers, because there's lots of business services that'll say, oh, we'll help you with that, we'll help you with that, but they don't have people that have specific knowledge in the NDIS. And somehow the NDIS operates in its own realm of rules and scenarios. So having people that actually have that specific knowledge, I would really recommend, sticking with people that actually know how that NDIS is operating. So thanks for that, James.
Well, it's a good opportunity, I suppose, for us to segue into the final section, which is very specific, and I want to talk about the SCHADS Award. Now, this is the Social Community Home Care and Disability Services Industry Award. I'll start from the very beginning. This is one where we're kind of there'll be some people joining us here who are extremely familiar with this award, know it inside out, know all its provisions, and there'll be other people joining us who don't know what a modern award is, and that's the vast majority of clients when they join us. Not really an assumed knowledge. So a modern award is basically, it's a semi-legislative industrial instrument, and it sets minimum entitlements of employment in different industries and occupations. So you probably would have heard that there's a national minimum wage, and that's the minimum pay for all employees across the country that they're entitled to. Now, on top of that, modern awards then set minimums for specific industries or in specific occupations. So in this instance, there are special minimum entitlements for employees who work in the social, community, home care and disability services industry. Generally working within the NDIS, this award is going to apply. I will say that it's a very complicated award, and so I'm not going to dive into it in too much detail, because I'll probably be able to be relevant to one person joining, and then losing for everyone else, given how niche it is. But the main thing, I guess, to communicate is that it's going to apply to your business and your employees as a matter of law. And what I mean by that is it's not something you opt into. So whether the SCHADS Award applies has nothing to do with whether you want it to apply. So if you're in these particular industries, the social and community services sector, it has a specific definition under the award. I won't go through all of this now. There's that if you work in your business in the home care sector, again, specific under the award. The crisis assistance supported housing sector, and then the family daycare scheme sector. If your business is operating within that, and probably those first two, I imagine, are what captures a large number of people joining it today, it's very likely that this award is going to apply to you. Now, it applies in two ways. Number one, to your business. So you first got to decide whether your business fits into the definition under the award of, in this instance, those 4 dot points there. And then if it does, the next step is considering whether it applies specifically to one of your employees. Now, the award, it's a big, long document, but it has a classification structure where it talks about different levels of employee. So I might say, a level 1 employee performs this particular role and sets out those duties. Now, if your employee matches that description, then you know that that award is going to apply in relation to that particular employee, and then they'll be classified at that particular level. If your employee didn't fit anywhere into the classifications that are listed in the award, then you may have an argument to say that this award doesn't apply. So before we've really even, I guess, talked about what's the effect of the award, there's already a really complicated piece of work to do in terms of understanding, does it actually apply to you, before we go and consider what it actually means to be covered. But on that, it doesn't just set base rates of pay. So employees covered by the award are also entitled to things like overtime pay, penalty rates, so higher rates for working on, say, Saturdays or Sundays, entitled to particular allowances or loadings. And the award sets out all of the circumstances when an employee may be entitled to a particular higher amount of pay or a particular loading penalty, all of those types of things. So it's very specific, It's also industry specific as well. So it is appropriate for your industry and the work that you're doing, for the most part. So that's why they have these awards that are industry based, so they can try and set some rules that are actually a bit more relevant, to employers. A really important thing, and I'm conscious of time here as well, that I really want to get through, is the consequence for not getting it right. Now, the main consequence, if you don't get it right, and so is looking at liability for back pay of the entitlements that that worker might be owed under the award. So the award applies because the law says it does. The employee is entitled to whatever the award says the employee is entitled to. There's no contracting out of that. So if you haven't paid it, you've breached the award, you've breached the law. I've had one client in this particular sector, they were required to make a back payment of $6 million in wages for non-compliance with this particular award. Now, that happened over a couple of years, but they stumbled across it. They did an award audit and realised they hadn't been paying particular rates and allowances. When we calculated the back payment, that was $6 million that they had to back pay. I had just recently wrapped up another underpayment. A client had underpaid 10,000 of their employees. It was under a different award. Each employee was actually only entitled to a relatively small back payment, but across 10,000 employees, and then across 6 years is the period that we looked at, this limitation period that we looked at for the underpayment. They were in the many millions of back payment. The other thing that they had to deal with as well was then fronting up to the Fair Work Ombudsman, who's the regulator. This is a process that we took them through to basically turn up and confess our sins and say we've made a mistake. We've already back paid everyone, but we need to let you know about it because otherwise we risk being prosecuted. And that then kicked off what has been a 3-year process of entering into, it's called an enforceable undertaking, but they had to agree to some very strict parameters in order for the Fair Work Ombudsman to avoid prosecuting them. So obviously not every claim lands in a $6 million back payment, but very frequently it does. And even at a smaller level, there are further issues for you. It's not just paying back the back payment. There are also penalties that you can face as the business itself can have to pay penalties, but also individuals involved in breaches. So fines are also something you've got to think about, not just the liability itself. In terms of what then...
And the time that would be involved in engaging a law firm, providing all the documentation, going back 6 years of worth of payroll, just that alone has got my skin crawling, thinking, how would I fit that into, my daily operational time? Absolutely not. So that cost is not even the back pay. It's also the cost of your own time over that period.
100%. And then there's the reputational damage as well. Those matters.
Definitely.
Look, ours made it in the AFR, and the last one I won't mention the client and further damage the reputational impact for them. But it is absolutely those things are a bit catastrophic for a business. That all go beyond just the dollars itself.
But it's easy to do, right? It's easy to make that mistake.
Absolutely.
Even especially you were saying there, even if it's a small amount across 6 years, that becomes a big amount. And I think the point here is that the SCHADS Award is very complicated, and it's not something, again, as a business owner or a CEO or a CFO that you're going to be familiar with, no matter how large your organization is. And that's something that you should be having someone like LegalVision, make sure that your contract has the right SCHADS Award and the right rate, and that you're safe, and then you can move on to all the other challenges you have.
That's right. And so, and just briefly, because I'll see if we can wrap up now here, conscious of time. But the main things you're going to want to give attention to are: have you got a wage management process in place? Do you understand how you're paying people? Are you paying annualized salaries that cover everything? And if so, are they high enough? How are you rostering people? Do you understand what their ordinary hours of work are? Do you know when you've got to pay overtime? Do you know when you've got to pay penalties and allowances? So you can simplify things under the award, but you need to know all of that to make sure that the rates you're paying are correct, because small underpayments across even a small number of employees rack up very, very quickly, and then you've got the penalties on top of it. So we'll wrap things up there for now. I know we've got through a lot of content, so that will wrap up the main part of. I want to move to the resources that we've got available. There's a free download for an NDIS service agreement fact sheet, and then some resources from MyCareSpace. Maybe Bianca, can you just run us through those ones that are included there?
Yeah, I popped a link on the screen, NDIS provider toolkit, and that actually is your gateway into sales and marketing resources, insurance resources, legal resources, provider training. We do a lot of business support for NDIS providers because we are supporting so many NDIS providers. So you'll have that link in the information after the webinar, and you can just take a look, and there'll be something that will be really relevant, specific for NDIS providers that should help you.
Great. We've got another upcoming event, so you might also be interested. This is with our leasing team, navigating disputes and how to avoid some common conflicts. And I just want to briefly touch on, Bianca has very kindly spoken very nicely about her LegalVision experience and what we do at LegalVision. So it's a good opportunity just to talk about our membership. So as a member of LegalVision, your business gets unlimited access to all our full team of 100 specialist lawyers, and we cover all of your business's usual legal needs. It's unlimited consultations there. We like to think of it as having your own in-house counsel, and obviously for a fraction of the cost. We can cover unlimited document drafting and reviewing for your business contracts, unlimited legal advice consultations, which of course go into these modern award issues, unlimited domestic trademark registration as well, and much more. For those joining us who are in-house legal teams, general counsels, we can also assist you managing typically high volume BAU legal tasks. So we have a sort of specific offering for you there. Request a free consultation at the end. We can also talk to you about how we might be able to help you. I've had a look at all the questions that have come through, and I think the very vast majority of them are things that we've covered today. So in conscious of time, I don't.
We've done really well, James.
Well, yeah, we've got through a lot. I won't take any questions.
No, we have, and really relevant, specific pain points. And, just to kind of add to your blurb about the LegalVision service, what we have found really beneficial, and the reason we have partnered with LegalVision to support the NDIS providers that we're supporting is for the very reason that we've experienced what this looks like. And we have used your employment specialist, we've used your tax specialist, we've used your trademark specialist. And the benefit of having this kind of membership is that you're able to have a specialist in each type of legal need that you have. So without us having this, if I wanted to check something on trademark, I'd have to go and hire a trademark lawyer. If I wanted something on my tax and financial elements, I'd go and have to find someone that does that. Then I have to find someone that does employment, or I get one guy that says he does all of it, but he doesn't do it well. And instead, I get this group of specialists, and I'm able to switch between them for each legal need. And what it also does, I sound like one of those like 2 a.m. movies. And what's more is that you're not afraid to ask for legal help because you've paid for it already. You know what that legal help is going to cost you, that membership monthly. So every single contract that MyCareSpace signs goes to LegalVision first. Every single contract, whether it's software, whether it's partnerships, whether it's employees, anything we do that has a contract, it goes to LegalVision first, and they review it for us. And the flip side, anything we do where we need a contract. So you're going to protect yourself because it's there already. And you've already paid for it. So you're not going, is that going to cost me? Maybe I shouldn't do it. You're just going to keep doing it. So the risk level that you carry as an organization, even as a small one or a large one, you're already reducing it immensely. As a CEO, that is something, and a CFO, that is something that you should be thinking about all the time, because that's going to come back on you if you haven't protected yourself. So if there's any other questions there that you wanted to finish off with, James.
No, I mean, well, I will just say thank you. I think I'm going to bring you to all of my
Yeah,
business
we did really
meetings
well.
now on this
So
very kind words. No, we'll wrap it up now. For anyone who does have questions that we weren't able to cover, please make use of that consultation, and we'll use that as an opportunity to speak to you. But otherwise, thank you, Bianca, for joining me today, and thank you, everyone, for joining us. I hope it's been helpful for you.
yeah, thanks so much, James.